Good afternoon and welcome to this presentation of Dorsey & Whitney's annual training regarding municipal securities disclosure. This is a re-recording of a previously presented webinar. We will not have, obviously, a direct question and answer opportunity available as part of this re-recording. However, we do want to encourage you, if questions come up during your participation, please email your questions to the following email address: damman.brian@dorsey.com. That's DAMMAN@DORSEY.com. The program is being presented to you by myself, John Danos, my partner Dave Grossklaus, and our colleague Brian Damman. We're all public finance lawyers in Dorsey's Des Moines office, and we appreciate your participation. This program is designed not only to educate you on these municipal securities disclosure issues, but also to potentially help serve the annual training requirements for your local government issuer of bonds. We'd like to start the program off by helping to make sure we're all on the same page about some of the terms that we tend to throw around a little flippantly, assuming everybody understands them. Let us run through some glossary items. First, issuer. When you hear us say the words issuer or your issuer or issuer of bonds, we are referring to the governmental entity that is actually issuing the bonds or notes or other indebtedness in a particular instance. We'll also talk about financial advisors or municipal advisors. These are folks out there who serve as professional financial advisors to governmental issuers of bonds. Their role is as a consultant on budgetary and financial matters, and they are often quite critical in helping with the issuance of debt, either to the bond market or to other sources of credit. In addition to financial advisors, your issuer will also occasionally deal with another category of professionals in the arena of municipal finance, and these folks are called underwriters. Underwriters are investment bankers who will work for firms or companies that actually purchase bonds and resell them into the bond market. Underwriters can be critical resources, not only helping your issuer to access the market, but also helping to refine structures on debt issues. We'll talk about the SEC, and if you're not familiar with that, those are our main regulators in Washington, the Federal Securities and Exchange Commission. OSs and POSs are the offering documents or marketing documents that will be used to help your issuer find investors for a particular bond issue that will go to the bond market. When we say CDCs, these are continuing disclosure certificates. These are documents that will be described in great detail as the program goes on. But please know these are the contractual undertakings that your issuer will enter into to provide ongoing financial and operating data to the bond market while a particular bond issue remains outstanding. We'll talk about EMMA, the Electronic Municipal Market Access. This is a website and an electronic repository for all the information about municipal bond issuers, their disclosure filings and continuing disclosure filings. It is a critical technical tool for you to know about. It's quite important for continuing disclosure. More on that as the program continues. You'll hear us refer to dissemination agents and also to the agreements, dissemination agreements that we enter into with those agents. Dissemination agents are private professionals who will assist your city in processing its continuing disclosure filings. They provide reminder services and can help provide information gathering and posting services. And the agreements are simply the contracts that your issuer would enter into with those professionals, covering their services and the fees you might pay for them. Now, our objectives for the program are first to help you gain a better understanding of your issuer's post-issuance responsibilities, what happens after closing with respect to securities regulations, and to gain some tips on how your issuer might manage them. In addition to that, we're going to try to help provide you with an overview of the regulatory oversight that the SEC applies, the applicable rules, some of the context within which the SEC has taken enforcement actions. In other words, why this is important for your issuer. We'll also help to review the contents of a CDC and also introduce you to the idea of an ongoing disclosure policy for your issuer to try to help you stay up to date in managing and complying with these regulatory needs. We'll also enter into some discussion about how you comply with disclosure requirements leading up to the sale of bonds. Now, why is disclosure important? Well, it's important because, in part, the SEC tells us it's important. It's also important because we do disclosure because you're trying to sell bonds and maintain a good credit profile for your issuer. And so, to those ends, the SEC cares about disclosure because they want to ensure that there's transparency in the market. There are real-life investors out there buying, selling, trading positions in your issuer's bonds as part of their livelihood and as part of their future viability financially. So the SEC looks to protect those investors. They help to ensure that bonds sold to investors, not just with an initial sale, but also on the secondary market, are properly priced based on adequate and truthful information being provided by the issuers to the investors. Now, where does the SEC get its authority? Well, it comes from a couple of sources. First, your issuer is subject to SEC regulation through the anti-fraud provisions of federal securities laws. The SEC has direct authority to regulate your issuer in order to prevent fraud in the sale and trading of bonds and securities on the market. Also, the SEC directly regulates underwriters, those investment bankers I mentioned earlier, through Rule 15c212 under the Securities Exchange Act of 1934. And under that rule, before an underwriter participates in buying your issuer's bonds, they are required to ensure that your issuer has contractually agreed to provide ongoing continuing disclosure information in accordance with the rule. And that's where that CDC, Continuing Disclosure Certification document I mentioned earlier, comes in. Rule 15c212 has two main aspects that we focus on today. First, the rule prohibits an underwriter from purchasing or selling bonds without first making sure that that continuing disclosure covenant is being entered into by the issuer. That ongoing disclosure requirement will have two components. You'll hear them repeated several times today because it's critical to understand both of them. On the one hand, your issuer will need to promise to provide continuing disclosure through annual financial information reporting, which will always include audited financial statements, assuming your issuer is audited every year, and will oftentimes also include the updating of other information that was covered in your pre-sale preliminary official statement, or POS. Also, the second prong, material event notices. The SEC rule requires that if certain events happen that would be material to the secondary market making decisions about your issuer's bonds, you must in real time report those events onto EMMA and through that website to the market. In addition, Rule 15C212 requires that your final official statement include a description of any material non-compliance with continuing disclosure obligations on previous bond issues that have occurred within a 5-year window before you're issuing a new series of bonds. So you must do a 5-year look back, and if you've had stumblings or fallings down with respect to continuing disclosure compliance, you are obliged to make sure under the rule that those are being discussed in sort of a mea culpa fashion in your official statement. Now, we've provided you, as much as anything, just as a memory trigger, with a front cover of what a sample official statement might look like. Again, this is the offering document or advertising document that gets put together to help with the sale of your bonds. Now, who's responsible for the official statement? Let's be very clear. First of all, your issuer is responsible for the official statement. And when you're going to do an offering of bonds, you need to know who's preparing it, and you need to know, regardless of who's preparing it, your issuer is primarily responsible for the contents of that document. Simply by hiring a professional to prepare it for you does not relieve the issuer of responsibility. Again, under those anti-fraud provisions of the SEC, your issuer is responsible. Your issuer, and that includes your elected officials who govern your issuer, have an affirmative action to know the contents of the official statement, including the financial and operating data that's being included in the document. Please understand on that last bullet point that signing off on an official statement without first reading the document to check for accuracy, to check that it's a fulsome, accurate document, can be considered reckless by the SEC and can bring about justification for them bringing an anti-fraud case against the issuer. We've seen, and we'll talk about in more detail, several examples, particularly over the last decade, with increasing frequency of the SEC bringing enforcement actions against issuers and also against the individuals who are the staff and governing body members of those issuers when there are disclosure and continuing disclosure problems. You'll see on this slide some examples of language that would be included in a final official statement with respect to sort of reflections on whether you've kept up with continuing disclosure requirements. It does require, as noted earlier, that you must affirmatively state if you've fallen down in keeping up with the rule. And if you look at the next slide, you'll see an example of how we might treat that, where we would report failures to report material event filings, or if you've missed an annual filing, left out content that was required in an annual filing. These types of things would not only need to be cured, but would also need to be noted in your offering document in order to comply with the rule. On the next slide, you'll see, again, just a first page, because we're not going to go line by line through it, of exemplar of a continuing disclosure certificate, or CDC. This document, as you would track through it, it's going to have a lot of words on the page, but in essence, it gets to some fairly simple points. It is a promise on the part of your city to provide ongoing continuing disclosure to the secondary market in the years while your bond issue is outstanding, after the bonds have been sold, but before final maturity. And the document is going to say two things. One, you're going to file annual reports as an issuer. And your annual report, in most instances, if you're doing a bond issue over $1 million, is going to have to include audited financial statements, and it's going to have to include an updating of the financial and operating data that you included in the official statement with which you sold the bonds in the first place. And we've listed out some examples of the typical types of tables that are containing financial and operating data in these offering documents, and therefore are the types of tables that we oftentimes see in our local government issuer CDCs. In addition to doing the annual reporting, the CDC is going to tell you that you must do ongoing monitoring and reporting of material events that might occur, which would affect the street value, if you will, of your bonds. I'm not going to run you through all 14 of these material events. There are some of them that might quite literally never be relevant to the type of bonds that your issuer might do. There are others, like number one, payment delinquencies, that will be relevant to every debt issue that's out there. We'll use that as an example. If your issuer fails to make a payment or fails to make a payment timely, the rule and your CDC will require that your issuer notify the bond market through a posting on Emma that that delinquency occurred. With that, I'm going to turn the microphone over to Dave Grossklaus to continue our discussion.
Thank you, John. I'm going to start and talk just a little bit generally about how the SEC came to start increasing dramatically its oversight in this area. As one might expect, and as we might recall, back in 2007, as a result of the financial crisis, there were a number of realizations that there might be some problems in the general financial world. As part of that, the municipal world was swept in as a result of oversight regulations adopted as part of the Dodd-Frank Act. And so where prior to 2007, we would predominantly concern ourselves in this arena with tax issues as they relate to the Internal Revenue Service. The SEC started to become much more active, and so we started to be much more concerned and need to be more concerned going forward about our issuances as they relate to securities regulations. So I'll walk through in the next couple slides here a couple of instances where it's illustrative as to the SEC's increased oversight. So in 2013, after the recession and after some time to get Dodd-Frank in place, and then after some time for the SEC to get some rules in place, we started to see in 2013 now the SEC begin a much more active role with regard to regulatory matters for municipal debt instruments. 2013 especially was a watershed year in which a number of things occurred. The SEC, for the first time, assessed penalties against an issuer. In addition, in 2013, the SEC charged an issuer with a violation and actually issued a cease and desist order against the issuer. An additional issuer was cited for falsely stating to bond investors that it had been properly providing annual financial information and notices, the infamous information provided in your continuing disclosure sections of your official statements, and then the subsequent MCDC initiative that I'll talk about here in just a minute. In addition, the SEC charged an issuer for materially misleading investors by providing statements outside the securities disclosure documents. This was an instance where the SEC brought to task an issuer, more specifically its elected officials, for statements made in the political arena. And then lastly, one of the illustrations of advanced SEC oversight in 2013 was that did not matter size or amount of your issuance, because a very, very small issuer was cited, and it became quite evident that if there was a general notion amongst anyone that smallness of issuance size or issuer was a pass for disclosure deficiencies, that is a notion that was dispelled in 2013. By way of example, you'll see the city of Harrisburg, Pennsylvania. As I mentioned earlier, this was an instance where public statements were made by certain city officials that, in essence, the city's financials were in good order. In fact, they were not. In fact, the city of Harrisburg had significant financial deterioration, and much of the financial information available to bond investors was incomplete or outdated. In other words, misleading. The SEC actually brought an action and noted specifically that public officials need to be mindful of their statements made that might impact the investor public. I think the most notable aspect here, again, is for the first time the SEC is drawing a distinction between information that might actually be in your offering documents as compared to just public information made by public officials, in essence speaking as to the financials of the entity that they're elected to serve. Next, the city of Miami, Florida. Here, this is illustrative of, with respect to the actual city officials, in this case the budget director for Miami. There were charges brought against him with respect to securities fraud with regard to a number of municipal bond financings and other disclosures made by the city of Miami, Florida in their offering documents. The investigation that began in 2008, you can see these investigations not only are quite diligent and disruptive, but also lengthy in time and cost. But then in 2013, after the investigation of 5 years, the budget director was found to have made materially false and misleading statements and omissions about certain inter-fund transfers within the city's books. Next, the West Clark Community Schools example. As I said, lest you think that you're a small issuer and have some kind of general pass, this is the instance that should dissuade you of that notion. In 2013, West Clark Community School District, which was a very, very tiny school district, was charged by the SEC for making false claims in their offering document with respect to their ongoing compliance with their continuing disclosure. So this was predating of the MCDC Initiative, but this was really the first lobby, or volley I should say, across the bow by the SEC with respect to continuing disclosure and the statements that are made by issuers in their offering documents with respect to compliance with continuing disclosure. West Clark had been making statements that they were in compliance. In fact, they had not filed any continuing disclosure for 5 years, and thus the SEC brought charges pursuant to claims that the West Clark Community School District had properly failed and were thus in violation of 15C212 and 10B5 statements. Those are just a couple of small examples. There are many others. Hopefully those examples, though, do show you that beginning a couple years ago, the SEC is now certainly an entity for which we need to be mindful of as we issue bonds. As you'll see in the next slide, this all led and culminated in an initiative called the MCDC Initiative that began or was announced on March 10th of 2014. This initiative, commenced by the SEC, dealt with statements and compliance by issuers with their ongoing disclosure filings, namely, as John mentioned earlier, your continuing disclosure certificates. Those are contracts by the issuers with bondholders, and pursuant to those documents, the issuers are agreeing to provide ongoing financial information in compliance with 15C212. The MCDC initiative was really a two-part initiative, which caused great angst, but initially the SEC took action and reviewed the undertakings in the context of participation by underwriters. That culminated with then a review with respect and filing, if so chosen, by the issuers. As you can see, there were orders with respect, I don't think by happenstance, with regard to 72 underwriters, and then 72 issuer orders also were provided for. With respect to the underwriters and the 72 underwriter orders, there was an aggregate fine of $18 million, ranging on, with respect to the underwriters, from $20 to $500,000. There were 3 batches of orders issued, as you can see there. Each one of those batches of orders, so to speak, I think provided a fair amount of guidance as to where the SEC was trying to provide guidance going forward for everybody, as to how they viewed noncompliance with your continuing disclosure requirements. Just to circle back a minute, again, as by way of reminder, the official statement must disclose failures to make filings of audited financial statements as part of the compliance. The SEC called out an annual filings, for instance, made 33 days late. Failures to cross-reference EMMA, failures perhaps because of a mis-QSIP and those types of things were deemed not to be in compliance. And then I think one that is kind of a restatement of the obvious, but there's also a reminder that if you fail to comply, you're supposed to file a material event notice confirming that there was a failure to comply. As you can see there, it was also deemed to be a material event for failing to provide notice regarding advance refunding and associated redemptions of certain bonds. Hopefully, those are being picked up because, as you'll note, if you go back and take a look at the material events, that is an event that is deemed to be required for notice on EMMA. Other guidance that can be gleaned from the MCDC orders, silence in the official statement regarding history of compliance is deemed to be a statement of material compliance. Notice of failure to comply, as I said, must accompany a late or missing filing. Even if there were a lot of questions, but even to the extent you go back and you catch up your filings, that does not mean that you do not have to disclose noncompliance. And as you can see in the slide, misstatements or omissions cannot be cured by subsequently filing an amendment to an official statement. The context of this was someone having gone back 4 months after the OS was printed and amending the OS, but that does not cure your prior misstatements or omissions. With respect to issuers then, on August 24th of last year, the SEC publicized 71 settlements with issuers. It was a broad range of issuers from states, including authorities, school districts, charter schools, colleges, healthcare providers. Within those orders, there were actually 2 municipalities for which orders were issued by the SEC with regard to the MCDC program. While the issuers did not have to pay monetary damages, which had been determined if you, as an issuer, decided to file under MCDC, nonetheless, from a political perspective, the pain was quite evident, as there was required that the issuer had to, without admitting or denying findings, had to agree to cease and desist from future violations. In fact, as part of the settlement orders, the issuers did have to admit to committing securities fraud pursuant to Section 17A2 of the Act. In addition, each issuer did have to agree to establish written procedures and policies and so on and so forth, update past delinquent filings, and you can see there are a couple of other things, and cooperate with any subsequent investigations by the SEC. I think the practicality of those subsequent investigations will be now to the extent that underwriters may have filed information that would be different than what the issuers may have filed. I would suspect the SEC would be comparing notes and reviewing those to see where filings were made that were inconsistent, and then going back and having further discussions with certain entities. So where that leaves us with regard ultimately to the order guidance, first of all, precise language with respect to your noncompliance is imperative. If you haven't, you will hear from us quite often, and there's an awful lot of time spent by us on culling through and making through your statements with regard to continuing disclosure are accurate. The second, I think, piece of guidance would be that you must pay very close attention to your history, and it's absolutely necessary to be very precise in your language. And you have to ensure that the substance of each filing clearly satisfies your current undertakings as set forth in the continuing disclosure agreements that you've entered. On the next slide, you can just see the statements that were made with respect to guidance from the SEC. You can see there that while there were no monetary penalties against issuers, the statements that were made and had to be made in order to meet SEC requirements under MCDC were quite strict. One item also that provides further guidance, you have to be very careful with regard to your cross-references of filings. In addition, making filings in the wrong location can constitute noncompliance, failure to timely link, and failure to include all required content in the notices. These are all items that actually do constitute noncompliance. As you can see from orders with regard to Memphis, the state of Minnesota, and the Lawrence Memorial Hospital. In addition, failure to file notice of defeasance constitutes material noncompliance. This on its face may seem a little bit odd because, in fact, the bonds are being defeased, or in many cases they have been defeased. Nonetheless, that is a material event, that does constitute material noncompliance. Sorry. Again, just to keep in mind, as part of this review, I would suggest that on an annual basis, if not at each time you issue, an issuer should take a look at their existing continuing disclosure agreements just to remind themselves what they have entered into contractually and agreed to provide on an ongoing basis. I would also add, in the interim between our initial recording and this recording, there has been rules just put forth by the SEC that would add to material events, and I don't know if we'll be talking about those, but those will probably be coming online here in the next 60 days. I'm going to turn over to a couple pages and conclude my remarks. It would leave you with regard to what MCDC taught us, and that is that the SEC takes your continuing disclosure very seriously. The need to be meticulous is ever present, and the need to pay very close attention to the statements you're making in your official statements with regard to continuing disclosure really is, in the eyes of the SEC, a very important matter. With that, I'm going to turn the program over to my colleague, Brian Damman.
Thank you, Dave. John and David provided an excellent backdrop on the fundamentals of continuing disclosure as well as where we are in the regulatory scheme with the SEC and where they regard continuing disclosure. And so we've developed a policy that many of you have adopted that helps kind of navigate the field of the continuing disclosure law and where it is today. So we can parse the continuing disclosure, disclosure into two aspects, and this is what John touched on earlier. There's the primary disclosure, which is essentially preparing the preliminary official statement and preparing the official statement. And then there's the secondary disclosure. That's what survives throughout the bonds, which is an annual updating and an updating when a material event occurs. So these policies have three aspects. The first is preparing and approving the official statements, again, that primary disclosure. The second aspect is making sure that you're complying with the continuing disclosure requirements. And then third and finally is ensuring that your staff and your elected officials are all aware of the requirements and the obligations undertaken by the issuer. And that's essentially what we're doing today. We're walking through the basics, the law, and the processes to follow to comply with your rules. As a reminder, under federal anti-fraud law, your official statement can't contain an untrue statement of material fact or omit to state a material fact necessary to make the statements in light of the circumstances under which they were made not misleading. That's why we have so many eyes looking over the official statement. And an underwriter, municipal advisor, or law firm may assist you in preparing the official statement, but it's very important that you review the OS for accuracy before it is published. And this echoes John's point earlier, the idea that you've got a lot of hands on this deal, but at the end of the day, it's up to your issuer to ensure that everything is accurate and nothing is omitted. So we have a 5-step process to ensure accuracy, and kind of the step before the first step is ensuring that you have a disclosure officer, which is essentially a point person to lead you through the process of publishing your official statement. At step 1, at the commencement of a financing, the disclosure officer should develop a plan for preparing the official statement and a schedule that allows sufficient time for all the required work and reviewing by all members of the finance team, including your elected officers. The second step, the disclosure officer needs to be responsible for managing the preparation process for the OS, and they need to obtain assistance from any other participants within the issuer, as well as legal and financial professionals as is necessary and appropriate. Third, the disclosure officer will be responsible for developing a program for coordinating staff review of the disclosure information and obtaining a formal sign-off from staff on the disclosure documents. This is a lot of checking the boxes to make sure that every piece is being reviewed, especially the issuer-specific information that who's in a better seat to make the decision or know the information than the issuer themselves. Step 4, the disclosure officer shall ensure that any previous failure to comply with the continuing disclosure obligations during the prior 5-year period is disclosed in the official statement. So this is the MCDC Initiative that Dave was talking about earlier. This is the ensuring that each annual filing is being made and that in the official statement we're accurately portraying the history of the issuer's continuing disclosure compliance. The fifth and final step here, the issuer's governing body should be given not less than 7 days to review an official statement prior to being asked to vote on its approval. It gives the board members or the elected officials time to proof it, ensure that everything is accurate, and the elected representative should be directed to contact the disclosure officer, who will be basically acting as a liaison during the process to discuss any potential issues or any other comments on the official statement. We can move on to the second aspect of disclosure compliance. This is the continuing disclosure. The issuer will be required to file or cause to be filed necessary items under the CDCs in a searchable electronic format at the Electronic Municipal Market Access, or EMMA portal. There's the website's link on the slide. So to ensure this compliance, we've got 13 points for consideration for continuing disclosure. First is the overall responsibility for CD compliance. This is going to be the disclosure officer again. They'll be responsible for compliance with the CDCs, and that's going to include annual filings, material event notice filings, the very rare voluntary filings, and any other filings that may be required by the CDC. So prior to execution of the CDC, this is at the time that the deal is in place before the bonds are even being offered, there needs to be a conversation with bond counsel, any disclosure counsel, underwriter, or financial municipal advisor to make sure that everybody's on the same page of what's being required in these documents. What tables are needing to be updated? What is a realistic turnaround time for getting audited financial statements filed? What material events are required? That's a conversation that everybody should be on the same page with. With respect to public statements and information, the disclosure officer has primary responsibility for ensuring that the statements or releases of information relating to the issuer's finances to the public that are reasonably expected to reach investors in the financial markets are accurate and not misleading in any material respect, and that includes website updates, press releases, and market notices. And the public officials and the disclosure officer will work together to ensure that all public statements and information released by the issuer are accurate and not misleading in all material respects. And you may recall in what Dave was discussing that this is something that the SEC has spoken to before, that it's not only what's in the document itself, it's statements made to the public that are subject to review here. That goes beyond mere puffery, but misrepresentations that in the total mix of information impact an investor's decision. We can move on now to outstanding bond issues. Disclosure officer is responsible for compiling and maintaining a list of all outstanding bond issues subject to continued disclosure. That includes noting the applicable filing dates. And we've included this handy table to have a macro view of exactly all the continuing disclosure obligations that your issuer has entered into. Basically a master tracking table that includes the name of the bond issue, the date, the final maturity date, whether you've engaged a dissemination agent, QSIP, which is essentially a serial number for the last maturity of the bond, and perhaps most importantly, the far right-hand column, the deadline for the annual report. You'll also want to retain copies of the CDC, the official statement, and any dissemination agent agreement materials. The disclosure officer is responsible for retaining all of these, and I would say keep it in the same file as your master tracking table as well. They serve as very important references when you're preparing your annual filings. We move along to a per issue table. The disclosure officer should document and track the required information to be filed, including dates such information is filed using the disclosure table part 2 of the policy. So this is for one bond. You list the name of the bonds, the date of the issue, and then the next columns are basically where you include the annual filings, unaudited, and any other notable information for each year. You can actually sign up with Emma for email reminders, and the Emma website also provides quite a great deal of training for how to navigate and how to even do filing on your own if you choose not to engage a dissemination agent. So these are suggested timelines. I would say as soon as you have the information available, it's a good time to start filing on Emma, but at least 30 days prior to the earliest filing deadline listed on your disclosure table, you should start the process of gathering all the necessary information. At least 10 days before the filing deadline, you should be determining whether everything has been gathered up, following up on the items that you didn't have initially, and kind of proofing the materials to ensure that they're ready to be filed. And at least 3 days prior to each filing deadline is a good time to file. Again, even better if you're filing before then. And after the filing, it's worth confirming, looking online yourself to see that these filings had been made. Listed event filings, this goes back to the long list of 14 items that both John and Dave talked about. You're required to make filings of any of these material events within 10 business days of such events. So I have this slide as well. It's the same as what John discussed earlier. The most important ones, he mentioned number 1, payment delinquencies. The others don't happen terribly often. Numbers 8, 9, and 10, as bond calls, defeasances, and rating changes, are kind of the typical hiccups that we come across that require material event filings. You also should have a contact person for investor inquiries, and that person ought to be the disclosure officer, basically handling any questions that investors may approach with, and oftentimes that's a good chance for that disclosure officer to say, talk to my municipal advisor, talk to my underwriter, kind of forward those questions along too. Voluntary information filing. If you feel the need to file information voluntarily, the disclosure officer is the person to do that. I would say before you do anything like that, contact bond counsel, disclosure counsel, under our municipal advisor, someone to see if they think it ought to be filed as well, because at the end of the day, you're making a statement to the SEC by filing this on it. That moves us to the third and final aspect of the disclosure policies, and that's what we're sitting here and doing today. Staff and members of the governing body should be aware of these procedures that we've just discussed, so continuous training is important to teach any new individuals and remind current individuals of the issuer's continuing disclosure obligations. There's kind of 3 formats of training that will aid in this. There's the annual training, which we're doing today. There's the specific training, which is best to do when a person is new or doesn't know the information yet, or governing body training, which is a biennial training. So first, the annual training, the disclosure officer is responsible for scheduling annual training of the issuer employees regarding disclosure and financial reporting obligations of the federal securities laws, including a complete review of disclosure policy, 15C212, and material events required to be reported pursuant to the rule, as well as the issuer's obligations under federal securities laws. It's worth having in your file, your disclosure file, a sort of a certificate saying, yes, in fact, we have done the annual training. Oftentimes policies say within the 6 years of a fiscal year end to have such annual training. This here is a good example of something that you could use for such a certificate just to have in file confirmation that yes, the issuer is aware of their requirements. Specific training, as I mentioned before, when appropriate, the disclosure officer should conduct training with individuals on those persons' specific roles and responsibilities in the disclosure and financial reporting process. Last, every 2 years, the disclosure officer should schedule a training session for the issuer's governing body on the issuer's disclosure policy and disclosure and financial reporting requirements of the federal securities laws. With that, I will turn it over to John, who has a few concluding remarks to make here as well.
Thank you, Brian. So, as we wrap up, just a few concluding remarks. One thing that we wanted to make sure that everybody understood, on an increasing frequency, we're being engaged as lawyers to serve in the role of disclosure counsel for our issuer clients when they are doing bond issues. You've heard those words, disclosure counsel, used by me and my colleagues during the program today. We felt we'd be remiss to not try to clarify that a little bit before we close. Traditionally, you're all used to us being involved as bond counsel if we serve in that capacity to your issuer. Bond counsel typically is charged with looking at the state of Iowa laws and regulations that might apply to your debt issue, and also to looking at federal tax law with respect to the bonds that you're issuing for tax-exempt interest. Disclosure counsel is a close cousin to that. As lawyers, we can also serve as your legal counsel with respect to these federal securities regulatory matters that we've been discussing today. Please know that our services in that regard are available anytime your issuer is doing a debt issue. As disclosure counsel, we will take on the task that we would not ordinarily do as bond counsel of conducting due diligence into your issuer and the bonds that are being offered, assisting with the preparation of the official statement in conjunction with the sale of the bonds, and assisting the issuer in conducting a fulsome review of that official statement. Having said that, we do not typically take on the role of preparing the financial and operating tables and data that are included in the official statement, but we will coordinate with the issuer and with other professionals who are involved with compiling that information. Importantly, we'll help to make sure that you're identifying any risks that might need to be identified for potential investors. And at closing, we will issue a specialized sort of legal opinion that we would call a 10b-5 opinion to the issuer, and if the circumstances are right, to the underwriter, so that they can rely on that opinion as they're purchasing and reselling the bonds. Some takeaways from the program. First and foremost, we really do appreciate you taking the time to listen in. Please, if you take away nothing else, understand there are two aspects to these securities disclosure rules. Some of them relate to the events and days leading up to the initial sale of your bonds, but they don't end then. The second prong is all of this continuing disclosure that we've talked about in detail today. These ongoing post-issuance requirements include the filing of the annual reports, but also the monitoring of the financial situation of your issuer and your bonds, so that you are prepared to make any necessary material event filings. I would like to reiterate something from a very practical standpoint that Brian said earlier. Please be aware, anytime you are going to make any kind of a posting onto Emma, you must understand that that is a direct communication from your issuer to the bond market and significantly to the regulators. And so before any such posting is made onto Emma, we urge you to be contacting legal counsel in order to make sure that the contents of that filing are crafted appropriately, and to make sure that the filing is being done necessarily. We want to urge you to keep up with the annual training requirements. We want to urge you to visit and revisit your policies and procedures with respect to these disclosure matters. And if your issuer has not yet adopted a set of procedures, please don't hesitate to reach out to us. We'd be happy to provide. On a final note, questions, as noted earlier, can be directed to Brian's email. He'll make all of us aware of them, and we'll be sure to get you a response. On our final slide here, you can see the contact information for our whole public finance team. We are available to you to not only answer questions, but also to tailor any training or programmatic efforts that you might want to undertake with your staff, yourself, or your elected officials in order to refine your practices in this arena of bond law. Thank you for your participation today. Brian.